Listen, Mr. Demons is entitled to heightened due process. The state is seeking the death penalty. It is very clear that one of his lawyers is under investigation. The one thing I can tell you is not going to happen is someone that has been in custody for 2,160 days, his trial is not going to be delayed under any circumstance. How are you feeling this morning?
Confused.
Your head is clear? You're not hearing voices. You hear your lawyers. You're talking to your lawyers. You understand what's going on this morning? Okay.
YNW Melly appeared in court today for motions, but of course something went wrong. The state was caught lying on a motion, and defense lawyers show the judge. The judge also orders the state to hand over their Apple iCloud search warrant of Melly's defense lawyer's Apple iCloud account. At one point, Melly has to speak to the judge, so we actually hear him talking for the first time in a year and a half. Pretty wild stuff, though. Hit subscribe. Here we go, boys. Oh, there's Raven Liberty. Looks like she made it. And there's Stu. Oh, there's Melly's mom. Oh, here comes Melly. Let's see if we get anything productive done today. These two aren't allowed to talk in person, really. She's had to talk to him in one of those glass partition rooms. I really want to know what she just whispered there. 2,100 days in jail, that man's still smiling. He's smiling at his mama. Oh boy, she's crying. I'm gonna be honest, boys. Raven Liberty got some crazy eyes. Look at this. She looked crazy as hell. Alright, audio finally came on. Judge came in. Let's go.
Okay, so this is just a continuation of yesterday. I did get, and I read the state's motion for rehearing and reconsideration of the Apple search warrant related to attorney Raven Liberty. I don't know that I actually conducted a formal hearing. I just asked the state to turn over a copy of the search warrant and affidavit.
Let's see if they actually turn it over. I'd say it's like 50-50 chance that they come up with an excuse to not turn over the search warrant and affidavit.
Would you agree that they're entitled to a copy of just the search warrant, not the affidavit, just the search warrant?
At some point, but not at this point necessarily.
Told you. She doesn't agree to hand this over right now.
Can you explain that to me? Because if I signed a search warrant for someone's home and BSO goes to their home and executes the search warrant and they're there, they give them a copy of the search warrant.
Correct. But
upon
in
its
this case,
execution.
it's Apple that the warrant is being executed upon, not the party themselves.
And you think your authority says that she's not even entitled to a copy of the search warrant?
Yeah, that's correct, Judge. Yes.
That's your position?
Yes, Judge.
Okay.
If you're new to the channel, please hit subscribe. I appreciate the support. Back to the video, boys. What? It's just a search warrant. I don't understand what's going on here.
Okay. Well, over the state's objection, I'm ordering you to turn over a copy of the search warrant. I'll put that in a written form today so you can litigate that as you see fit. But I certainly think she's entitled to a copy of the search warrant.
Judge whipped his dick out and put it on the table and said, "You're giving it over. Let's go, boys."
Defense, I'm happy to hear anything you want to tell me, but based on our discussion yesterday, I think where we're at is I need to give you a date very soon in the future, a date in February, which is what I'm looking at. And at that point in time, you're going to have to come back in here and tell me, and I'm going to have a discussion with Mr. Demons. I'm going to start that discussion this morning so he understands that he's the captain of the ship. This is his decision, but he's going to have to tell me if he wants Ms. Liberty to continue to be his lawyer or not. He's going to have to tell me if he wants all of you to continue to be his lawyers or not, or he's going to have to tell me that he's going to seek other counsel, but I think that needs to happen sooner rather than later.
We concur with that.
Looks like he already made up his mind, low-key. The way he just looked at her, I feel like he's going to be like, fuck it, let's just go on. I don't need new lawyers, because he knows it's going to delay it more. He's going to trial 9 months for a capital murder case.
I'm confused, and I apologize to the court. Is the court entertaining this motion for reconsideration and not?
There was no motion or ruling. I think she's entitled to listen, Mr. Demons is entitled to heightened due process. The state is seeking the death penalty. It is very clear that one of his lawyers is under investigation right now. He is entitled to have as much information as I have the ability to give him before he has to make a decision. Is there a conflict of interest? Does he want to waive that conflict of interest and continue with that lawyer as part of his representation? Or does he not? Does he want the lawyer to withdraw? And again, he's the captain of the ship.
Absolutely.
He makes this decision. If you all had some other authority that says, I have some additional power to assist in the fact-finding here, I would hear what the state has to say about it, but I would probably be inclined to do that. But my inherent authority, or citing the U.S. Constitution, although I very strongly believe in the U.S. Constitution, this is I'm not involved in this. The underlying facts that are going to make a determination is whether there's a conflict and what Mr. Demons wants to do. This is completely 100% a decision between himself and his lawyers. I don't
We
have anything to
agree.
do
We're
with
not
it.
disputing that.
So I don't know what else I can do at this point. You've asked me to press pause on all these motions. I'll press pause. I'm not going to move his trial date. His trial is going forward in September.
I like how he's keeping his foot down on the trial date, but come on, man, these motions need to get done. I know it's the defense saying they don't want to do them. I guess they're not doing them then.
They're heard next month, or they're heard in March, or they're heard in August, or they're heard contemporaneously during his trial, which again would not be the
Correct.
most ideal way to do things. If that's what ends up happening, that's what ends up happening. The one thing I can tell you is not going to happen is someone that has been in custody for 2,160 days, his trial is not going to be delayed under any circumstance. So that being said, what else would you like me to do this morning?
Well, a couple things. Since the state filed a motion for rehearing, there are misstatements in their motion that need to be corrected. Since we received this early this morning and saw it for the first time, we did not file any written plea response. And if I may, just go through the corrections that we saw.
Dude, the judge is so over this shit.
Number one, it says the search warrant was issued in December of 2024. It was 23, not 24, a year earlier.
We agree with that, Judge. That we
In paragraph number 2, they said that the state disclosed an ongoing investigation to Miss Liberty. That is absolutely untrue. We learned of it through Apple. They confirmed it yesterday for the first time, over a year after the search warrant was executed.
Wait, they lied? The state get caught lying here?
Number 5 indicates that this investigation is separate and apart from the defendant's current case. It conflicts with paragraph 11 that implies that this investigation is related to the tampering case of Mr. Demons. Is it unrelated or is it related? I think the court needs to know that, because if it's related, I believe, and we will file a written response under discovery, he's entitled to that information. Anything that leads to relevant and important information. And I'm not asking the court to rule on it at this point, but I want the court to know that if it's related to his present charges under 3.220, we're entitled to that information. They make a statement,
I can't get over this judge's face, bro.
regardless of what Demons wants and is willing to waive the conflict, they believe that Ms. Raven must get off the case, regardless of that. That's their assertion. They have to prove it.
The state wants Miss Liberty off the case? Damn. He's saying they're asserting that. This is so messy, and I can't believe this is happening. Just like I said yesterday, it might be best for him just to get rid of her, dude.
And I want to put the state on notice that they must prove. They can't merely allege that the conflict is so extent that even if this young man wants to waive it, they're going to come in here and say she must get off the case. That's what they say in this plea in paragraph number 11. That's a question for the court to determine, and they have to present evidence of that fact. We are still under the same impression that we don't have enough information. Pursuant to Your Honor's request, Mr. Aronson and I spoke to Mr. Demons. I call him Melly if the court will allow me.
I'd actually prefer that you use.
Mr. Demons?
Yeah.
Fair enough.
Thank you.
Sounds like the judge doesn't want them to refer to him as Melly. I wonder if he's going to make them do that the entire trial.
He informed us that he doesn't have enough information
Well,
to make that decision.
Oh, so he hasn't made up his mind. And look at this shot of the judge's face.
You're
And I
talking to
wanna
me about
put-
privileged communication.
Well,
I'm going to talk to Mr. Devins at the conclusion of the hearing this morning. Everything that I'm allowed to talk to him about. I don't want to hear about anything that you all talk about.
I was just willing to proffer his statement that
Was Stu supposed to spill the beads? I don't think he was supposed to announce that Melly hasn't made up his mind yet because he doesn't know all the information.
and we would, of course, ask the court to deny their motion for rehearing.
We all take supplements, or at least we should, right? Why are so many supplement companies charging ridiculous prices for supplements that aren't that special? That's why I want to introduce you guys to Live Good, a brand that's turning the supplement industry on its head. Live Good believes that everyone deserves access to high quality supplements without the insane markup prices. They offer premium products formulated by an industry leading team of natural health experts, and they cut out the middleman to sell them at the lowest prices anywhere. I recently got my hands on the Ultra Magnesium Complex and the vitamins D3 and K2. Since taking the magnesium, I've noticed my sleep is better and my overall mood. There's so many benefits to taking magnesium, I can't even list them here. Research it yourself, you'll see. And D3 and K2 can promote heart health by preventing the hardening of arteries. So many benefits I can't even list as well. It helps with blood circulation and your immune system. These two supplements right here have been a game changer for me, guys, for real. They also have organic super greens, multivitamins, creatine, collagen, weight loss products, detox and hormone products, and skincare. Literally anything you can think of, all at a good price you can actually afford. No wonder they're the fastest growing supplement brand with over 1.5 million customers and counting. Ready to make the switch and start saving? Use our link and you can save an additional 10% already off the top of the low prices. Just go to livegood.com/CUFBOYS to get 10% off your first order. That's livegood.com/CUFBOYS. Don't miss out on this opportunity to invest in your health without overspending. Back to the video, boys.
And rule consistently with what you ruled yesterday, that they not only have to produce the search warrant, but the affidavit.
Well, do you want to respond to any of the case law they cited about ongoing investigations? That would relate to the affidavit.
Well, it relates, if it's related to his present charges under Rule 3.220, they must turn it over. So let him come in here and make a representation that it is either unrelated, totally different, or if it's in fact related, he has a right to see that information. 3.220 is clear on that. Anything that could lead to relevant information must be disclosed.
Judge, I could just ask, I know you said file a notice of hearing, if we could have a deadline like by February 1st, so we don't end up in the same position we did this time where it was filed, 3 business days before.
Let's see, we're talking about February 18th, so how about the end of business on February the 7th? How about that?
That's fine, Judge.
All right, so that goes for both sides. If there's anything you want me to hear on February the 18th, just file a notice of hearing, identify exactly what it is that you want me to hear, and I'm going to see him February the 18th at 9:30 a.m. Again, we'll call it all pending motions. Maybe we'll be able to work all day, and maybe we'll be able to do nothing. I guess that's really going to be up to you all. State, is there any other requests that you have this morning?
Yes, Judge, as to the search warrant itself that Your Honor is going to compel us to provide, I'd ask that we have until February 1st just so that we have time to pursue the appellate remedies in the meantime, and then I'd also ask that it provided to Your Honor in camera first, because it's the state's position that there are, even in the search warrant itself, certain things that make reference to other targets of the investigation, which are confidential, privileged, and would jeopardize the investigation. So we would ask that Your Honor review that in camera, if any necessary redactions have to be made, and then it can be provided to defense.
We would object to that procedure, and they've had a year, over a year, to produce these documents, so it's no surprise.
Stu ain't playing games. So they want an in-camera review of the search warrant because they're saying it could jeopardize the investigation, and they want to redact certain things.
We would ask that to be given to us by the end of tomorrow.
Yeah, they want February 1st. Another 3 weeks on this search warrant. I thought Judge said they needed it today. Like, what the fuck are we doing? The silence.
Okay, so listen, over the defense objection, State, this is what I'll do. I'm ordering you to turn over a copy of the search warrant. I need you to get that to me by a week from today. That's January 14th. End of the day, January the 14th. That comes to me,
Yes, Judge.
and then I'll review it, and then I'll distribute it.
So he gave him a week. They're so lucky because yesterday he was saying it was going to be a day or two. So now they have 7 days for the search warrant.
I can't imagine there's anything in there I'm going to redact. It doesn't matter. The state's free to investigate whoever they want for anything they want. To do this in the midst of a capital case, State, I realize some things are going to happen that you might not find ideal, but that is of your doing because you've chosen to do this in the middle of a capital case. So
Yeah, a very messy tactic. I swear it was on purpose to delay the trial. They didn't need to do this investigation during the capital murder trial. Finish this trial and then do that. Try to charge his lawyer if you want to.
Mr. Demon's heightened due process rights will take precedent over every other matter in this case, obviously. So
Yikes. Not good for the state. Because it's death penalty, the heightened due process rights take over anything.
that's just the way it's going to have to be. But I'll grant your request over the defense objection, at least as to that.
He's looking right at him.
We would ask that the state submit the affidavit.
Well, the case law seems pretty clear that you're not entitled to that. But if you have some competing authority, I'm happy to look at it.
Yes, sir.
Your Honor, on another note, I was a little confused yesterday as to whether or not you have lifted the stay as far as discovery and we can start discovery again on everything, or we're still under that stay order. Just asking for
I asked both sides if you wanted to do that. I thought you both told me that you did want to do that you wanted to do the things that you can do.
I want to do everything.
I agree with you.
But
Time is short, but
the state is the one that asked for the stay.
Well, state, what do you want me to do?
They don't want to do anything. They want to delay the trial. This whole appeal they did was based on an evidence appeal that I can't remember, but it's pointless because it's not even important. Like, they literally appealed this for it to go to the appellate courts to waste time. I'm not joking. That's literally what happened. I made other videos on it.
We need to speak with the Attorney General's office because we have that stay for a reason with certain things, but we have plenty to do
outside of that
first. So
Okay,
we have
well,
some-
why don't we do the things that we all agree we can do? So the answer to Mr. Anderson's question is yes. Without objection from either side, the stay is lifted to the extent that we can litigate any matter that's not currently before the
Well,
court.
no, we are objecting to that, Judge.
That was already done by Judge Murphy.
Right, that's already been
Judge
done.
Murphy already lifted the
He
stay.
As to-
modified it.
right, he
So that
modified
we
it.
could do ongoing
Oh,
discovery
okay.
as to things that were not up on appeal.
Okay.
I'm a little concerned that with the lack of information that exists in this case, for him to even opine on where to go right now, based on what? The paragraph in their motion that says he has to make a decision now because we told him there's a conflict. Doesn't rise
I'm not
to-
going to ask him any questions. I'm just going to explain to him the choices that he's made. No different than a defendant deciding to testify or not testify at a trial.
I didn't know there was plans to ask him questions. I think there's a miscommunication here.
I can ask him any questions. I'm telling him what's coming. Because at some point, he is going to have to tell me what he wants me to do.
And of course, we're going to object at this point, and until the time that he's fully informed as to what there is that may be a conflict, he is in no position to answer, to make an opinion as to whether...
I'm not asking his opinion. You're objecting to me talking to your client about his right?
It depends on what you say, Judge, but I am prefacing what your comments are because I was under the impression that you were going to inquire with him as to whether or not that he finds there's a conflict.
No, I'm not.
Okay, great.
I'm not. All I'm going to do this morning is explain to Mr. Demons that at some point this is going to be his choice. I'm sure his lawyers will give him their best advice, but this is going to be his decision. And he may not agree with your advice at some point. Just like a defendant may decide to testify or not testify and not follow their lawyer's advice. But I take this decision to be the same way. It's a fundamental decision. This is a client decision. This isn't a lawyer decision. So, Mr. Demons, raise your right hand for me.
What the fuck? He's going under oath?
You don't have to stand. You're okay. You can sit. You swear to tell the truth, whole truth, nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Please state your full name.
Chanel Maurice Denny,
How old are you?
25.
How far did you go in school?
I graduated. Well, I got my GED.
Do you read and understand the English language?
Yes.
Are you presently under the influence of any drugs, medication, or alcohol?
No.
Have you ever been treated for a mental illness?
No.
Are they giving you any medication in the jail right now?
No.
Wasn't he diagnosed with like multiple personality disorder? Or was that just him self-diagnosing situation?
How are you feeling this morning?
Confused.
Confused.
I understand. I'm a little confused myself. Your head is clear? You're not hearing voices. You
No.
hear your lawyers. You're talking to your lawyers. You understand what's going on this morning?
Yeah.
Okay.
You're not hearing voices.
You're, just like any other defendant, you're entitled to have a conflict-free lawyer or lawyers representing you. Okay, a lawyer that has your best interest in mind to the exclusion of anything else. You with me so far?
Yes.
Okay. The state has told you that one of your lawyers is currently under investigation. For what? I have no idea. But there's some ongoing criminal investigation. Okay? You with me so far?
Yes.
Okay. So, this, what your lawyers correctly pointed out yesterday, raises immediately what we call a conflict of interest. In other words, maybe at some point during this litigation or some point during the trial, my lawyer's not going to do what's the best thing for me. My lawyer's going to do what's the best thing for my lawyer. And your two interests are separate. You understand that?
Yes, sir.
Okay. Once your lawyers have had the opportunity to investigate all this, to get you all the information they can possibly get, so they can talk to you about all this, at some point, you're going to have to make a decision about who you want your lawyers to be going forward. Are you with me on that?
Yes.
Okay. Even if there is a conflict, you can waive the conflict if you want and say, Judge, I understand there's a conflict, but that's okay. I like these lawyers. They're doing a great job for me. They did a great job for me in the past, and I don't want to change, lawyers this late in the game. You understand that?
Yes.
Or you could likewise say the opposite and say, Judge, I don't feel comfortable with this. I think there's a conflict. I don't think Miss Liberty should be my lawyer anymore. I don't think any of my lawyers should be my lawyer anymore. And I want to go get some new lawyers. And if you want to hire your own lawyers, you can go out there and hire anyone you want. And if you want me to appoint lawyers to represent you, you would have to file an application with the clerk's office. And if they find that you're financially qualified, I could appoint lawyers to represent you. You understand that?
Yes.
The whole point I'm trying to make with you today, sir, is that this is going to be your decision. Your decision. Your lawyers will give you their best advice, and you have some excellent lawyers, okay, about what they think you should do. But at the end of the day, you can follow their advice, or you don't have to follow their advice. It's your decision. Do you understand that?
Yes.
Okay. Do you have any questions for me about anything that I've said so far?
Can we have a moment, Your Honor?
Sure. No questions? All right. So, Mr. Jennings, I'm pressing pause on the conversation at this point. We're going to have the second half of this conversation at some point in the future. I hope it's sooner in the future rather than later, because the last point I want to make sure, and I'm giving you and your family and your lawyers as much notice of this as I can, your case is set for trial September the 10th, and that's not that far away. Do you understand that? Okay. Your case is going to go to trial on September the 10th. So if you change lawyers, you're going to get a group of lawyers in place that are going to have like 7 months to prepare a capital case. Okay? So the longer it takes to make this decision.
I'm going to object to what the court has just said. What you're telling him is right now that he is basically having to stay with us as his attorney, because if not, then he'll get another set of lawyers that will not be prepared, and they will only have 8 months to do what has taken years to do, and therefore you're pushing him into the corner that he has to stay with us. I don't think that's fair what the court has said.
Over your objection, sir. That's not what I'm saying at all.
I think he was really just trying to let him know that if he switches lawyers, they're only going to have 7 months. Like, you got to really think about that.
I want to make sure that you understand that time is of the essence. Do you understand that?
Yes, sir.
Okay. Okay.
All right, and that's it. No motions were heard for 2 days that were set on the schedule for full 16 hours of 2 days to hear motions, and no motions were ever heard. All over this investigation to one of his defense lawyers causing all this. And now we won't know anything until pretty much 6 weeks from now. So here's the state's motion for rehearing and reconsideration that they apparently lied on, that he pointed out earlier in this video. Honorable Court ordered them to require the state to provide the defense with a copy of a warrant issued December 2024. They admitted they filed this wrong. It was December 2023 when the warrant was issued, and they admitted that in court earlier. It's the state's position that the Honorable Court has overlooked and misapprehended several matters of fact. Further, the state requests the court reconsider its order. A trial court has the inherent power to reconsider a ruling upon appropriate motion by either counsel, while the court has jurisdiction of the case. They cite a case right here. As this Honorable Court referred to Rutledge v. State, requires the state to disclose, in fact, ongoing investigation relating to the defense attorney Raven Liberty, to compel the state to go beyond what is required by law as departure from the essential requirements of the law. Upon the state's assertion that there is an open and pending investigation stemming from defendant's present cases but entirely separate in its own right, it is then up to Miss Liberty to have the conversation with her client as well as assert herself whether she can ethically continue in her representation. To require the state to provide a copy of a warrant at issue of defense would require the state to disclose information regarding ongoing criminal investigation. Encompasses more parties than just Miss Liberty and involves numerous parties, requiring the state to divulge details of ongoing investigation. The Broward Sheriff's Office would set a dangerous precedent for the current state of criminal investigations. Unable to do their job without the threat of being forced to divulge their investigations prematurely would surely have effect of limiting the work of the police in Broward County. Requiring the state to produce a copy of a warrant would greatly impede the current investigation, allow suspects to avoid apprehension, allow for destruction of evidence, and is exactly why Florida expressly prohibits the disclosure of such information regarding active investigations. Investigations into attorneys, especially those involving potential criminal conduct, are often kept confidential to protect the integrity of the investigation and to avoid prejudicing ongoing proceedings. The state would further argue that the specific details of any potential conflict that may arise between Liberty and defendant is irrelevant. The defendant is aware that his attorney, Miss Liberty, is under investigation. This satisfies the defense's due process rights. Regardless of the details of the investigation, Miss Liberty has the ethical obligation to withdraw, even if the defendant were to waive the conflict. Wait, what? So that's the other part where they're saying is a lie. The state is asserting that she has to withdraw herself. So they do want Miss Liberty off this case. This is fucking crazy. And they cite this U.S. versus Pizzona, a New York 2006 case. The court held that if the attorney suffers from an actual conflict so severe that it impedes effective assistance, counsel should be disqualified, notwithstanding defense's desire to waive. If the activity for which the attorney is investigated is substantially related to the charges against the defendant, disqualification is necessary, notwithstanding the defense waiver. And they filed this yesterday. And here's the judge's order. Court hereby orders the state of Florida to provide a copy of the Apple iCloud search warrant for Raven Liberty, issued December 2023 to the court by close of business January 14th for in-camera review. Here's state's response to the defense motion to compel discovery. On January 8th, 2024, so almost exactly a year ago, state filed a list of 58 songs performed by the defendant that may be produced at trial. So this is when we found out that the new prosecutor wants to bring in songs of Melly songs and the lyrics. We're like, oh shit, that was a year ago now. Think about that. Defendant has filed a motion to compel additional information, including the titles of the song. These are already in the defendant's possession and are listed out in various supplemental discovery that the defendant now complains of. Name of writers and composers, name of the performers. Though not specified, all of the songs are alleged to have been performed in whole or in part by the defendant. Date of release, date written, date recorded, date and registration and copyright, date of registration with BMI. So Melly's team is forcing their hand because they don't know any of that information. That's what this says. They don't know any of this. Besides date of release, maybe, but they don't know any of this. None of the remaining items 2, 3 are within the state's possession. The state is well aware of its ongoing discovery obligations pursuant to blah, 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 and has provided the information is legally obligated to do. And now they cite some cases saying that they don't need to give over all that information. The information of the defendant seeks is information about his own songs that he's performed, his own licensing, and his own contracts. The information he seeks is more readily available to him than it is to the state. What the defense seeks to do here is to have the state do their work for them. No good cause has been shown as to why information is not accessible to them, or why the state can be compelled to produce something that is not under their physical possession or control. All right, that's pretty much it. This is a shit show. Can't believe it's still going on. I've been covering this case since it started. Think about that. Fucking 6 years of videos on my channel covering this case. Hit subscribe to the channel membership. Love you guys. Peace out.